Ladies and gentlemen, our session is about to start, so please be seated. Thank you. Welcome back, ladies and gentlemen. Here comes our third panel session on ASEAN guidelines on ODR and experience sharing from ODR providers. We are delighted to have Ms. Tapuiki Emmanuel as our moderator, Ms. Gusmalinda Sali, Ms. Irene D.T. Alogok, Mr. Nguyeng Anzong, and Mr. Visit Sri Watanapanya as our speakers. Ms. Ta is the CEO of IBRAM International Online Dispute Resolution Center. So Ms. Ta, the time is yours. Thank you.
As foreseen in the ASEAN Strategic Action Plan 2025, the ASEAN Committee on Consumer Protection established and launched the ASEAN Guidelines on ODR, which aims to assist ASEAN member states in developing and designing national ODR systems for the settlement of disputes arising from e-commerce transactions. Currently, only a few ASEAN member states have a national ODR system in place. It is a pleasure to be moderating this session in which we'll explore the ASEAN guidelines on ODR and draw out a number of key considerations in setting up or improving national ODR systems in the specific context of ASEAN. We have an excellent panel of speakers today who will also share their experience in terms of ODR development in their respective member states and examine some of the challenges regarding the implementation of ODR guidelines and how those challenges might be overcome. Today, I am delighted to be joined by four distinguished speakers. Joining us is in person Ms. Gusmalinda Sari, a trade analyst of the Consumer Protection Partnership Team Leader of the Directorate of Consumer Empowerment of the Ministry of Trade of Indonesia. Linda was the head of the Indonesian delegations in the 1820s of the ASEAN Committee on Consumer Protection and various international and regional forums in recent years. Linda will kickstart the discussion today by providing an overview of the ASEAN ODR guidelines and taking us through some of the key considerations and criteria when setting up ODR systems by ASEAN member states. Our next panelist will be Attorney Irene Alogok, Executive Director of the Office for Alternative Dispute Resolution of the Department of Justice of the Philippines. Irene has more than 10 years of extensive law practice and is a professor of law at various universities in her country and will be speaking to us today about the Philippine experience in ODR. She will also examine some of the challenges regarding the development and use of ODR in the Philippines. We will then move to Thailand and hear from Mr. Visit Siwatanapanya, legal counsel at the Thailand Arbitration Center. Visit also acts as tribunal secretary, and he will be speaking today about the national ODR system in Thailand. Our last speaker will be Mr. An Zung Nguyen, Director of the Department of General Economic Issues and Integration Studies of the Central Institute for Economic Management. Zung designed and led the implementation of the project promoting ODR in e-commerce to strengthen customer protection in Vietnam. And today he will give us an overview of the ODR pilot program conducted in Vietnam. We will then play a short video to introduce the ODR platform developed by IBRAM International Online Dispute Resolution Center. So that is our roadmap for the first part of the session and a very brief introduction to our speakers. I will now hand over to Linda to give us an overview of the ASEAN ODR guidelines and take us through some of the key considerations in designing and setting up national ODR systems. Thank you.
Thank you, Mr. I'm the only one a speaker in person now. Okay, good afternoon, distinguished delegates, ladies and gentlemen. First of all, allow me to extend our sincere gratitude to the ASEAN Secretariat, the Ministry of Trade and Industry, Hong Kong Special Administrative Region, People's Republic of China, and the Ministry of Justice, Hong Kong Special Administrative Region, People's Republic of China for this opportunity. Ladies and gentlemen, in this workshop, I will be to share about online dispute resolution in ASEAN based on the ASEAN guidelines on ODR. These ODR guidelines were developed with the support of consumer protection in ASEAN, implemented by GIZ and funded by the German Federal Ministry for Economic Cooperation and Development. These guidelines refer to ODR in the context of business to consumer, B2C, commercial transactions, and a complaint excludes transactions involving consumer goods, B2B, or those between a consumer and another consumer, C2C. ASEAN Community on Consumer Protection, or ACCP, is a sectoral body in ASEAN Economic Community responsible for cooperation in the field of consumer protection in ASEAN. The ACCP has been implementing its action plan called the SFCP, ASEAN Strategic Action Plan on Consumer Protection, 2016 until 2025. The SFCP has 4 strategic goals. The development of ODR falls under Strategic Goal 3. High consumer confidence in the AEC and cross-border commercial transaction is instituted. The expected outcome from this goal is new dispute resolution and redress mechanism are set up in ASEAN to resolve domestic and cross-border consumer complaints. There are initiatives or deliverables conducted to reach this outcome. 2 of them has been implemented, namely the feasibility study of ASEAN ODR network, which is endorsed by the ACCP in 2020, and the development of the ASEAN guidelines on online dispute resolution, which is endorsed and published in April 2022. These initiatives are also supporting the ASEAN high-level principle on consumer protection, especially Principle 4 and Principle 8. Based on the SFCP implementation schedule, following the feasibility study of ASEAN ODR network in 2020 and the development of ASEAN guidelines on ODR in 2022, IMS are encouraged to establish or strengthen their respective national ODR system and expected to be ready in linking them to the ASEAN ODR network post-2025. The feasibility study shows that the term ASEAN ODR network is not translated as one new ODR platform for all AMS, but an integration or interlink that connects existing ODR system in its AMS. The pilot project can be started at any time when at least 2 AMS respectively have an operationalized national ODR system. To facilitate the integration between ODR system, AMS, especially those who will participate in the pilot project, is expected to conduct dialogues to equate various technical aspects, especially IT requirements, procedures, and legal rules in carrying out ODR. This is the ASEAN guidelines on ODR, gives practical orientation for the establishment of national ODR system with non-binding design option to contextual in its AMS. This is the main characteristic of ODR in ASEAN. The national ODR system are generally an upgrade or further development of the existing ADR mechanism led by government. Mandate and active involvement of Consumer Protection Authority, flexible, voluntary, consensus-based settlement procedure. Available for different types on and offline B2C commercial transaction. It's also built to complement the existing offline mechanism, not replacing it. In order to further develop the system by integrating it to cross-sector or even cross-border mechanism, its IT design should ensure its openness and interoperability. ASEAN guidelines on ODR gives practical orientation for the establishment of national ODR systems with non-binding design option to be contextualized in its AMS. The guidelines consist of 5 major parts. They are design criteria, guiding principle, IT requirements, legal and procedural requirements, and regional and international cooperation. In designing a national ODR system, should follow certain criteria, such as the objectives and coverage of national ODR development must be determined based on government commitment or national policy document. The lead should have sufficient and clear legal authority in order to ensure streamlined efforts across sectors. Engage in continuous advocacy to promote stakeholder support and streamline effort across government entities. Identify and assign role to users of the ODR system, administration and accountability, degree of automation and funding. 2 important principles for an effective national ODR guideline are accessibility and transparency. A national ODR system should be accessible throughout the country even with limited connectivity. In terms of transparency, relevant information should be available for users. Reporting should be done regularly regarding the utilization of system, funding, and success rate. On the IT side, a national ODR system should have interoperability and adequate data security and privacy. Legal basis and procedures can be met new or referring to existing regulation depends on AMS context. One of the most important things is AMS should guarantee the legal recognition of electronic documents and communication, as well as the use and validity of electronic signature in ODR proceedings. Cooperation in regional level, mainly in developing ASEAN ODR network. AMS should actively explore the option of linking their national ODR system to the ACCP website. AMS is advised to actively engage through relevant international groupings and fora and consider entering into bilateral or multilateral cooperation regarding cross-border online dispute resolution. Milestone for the development of national ODR system can be set in 3 stages. For immediate actions, 2022 until 2023, AMS are expected to conduct necessary preparation such as assess existing legal and institutional framework, review good practices for references, cross-sectoral and stakeholder consultation, and develop concept and planning for establishing the national ODR system. For medium-term actions, 2024 until 2025, AMS are expected to set policy commitment, determine the host and lead of ODR system, allocate resource for setting up the system. develop IT, and set rules of procedures. AMS are also expected to conduct public awareness to promote the system. Monitoring and evaluation are also essential to ensure the effective in every step. For long-term actions post-2025, the national ODR system is expected to be fully operated effectively and taking steps for expansion and integration into ASEAN ODR network. In order to ensure success factor of the network, AMS should harmonize legal and procedural standards. From this presentation, we can take some conclusions. One, in setting up or upgrading their national ODR system, AMS are encouraged to use the ASEAN ODR guideline to ensure commonalities and address certain challenges. Two, to ensure the success of the national ODR system, regulation must be prepared comprehensively and investment schemes must be determined at least for medium-term operations. Three, system design on the IT side must be made flexible to allow development, expansion, and integration with other relevant systems. Four, it's important the national ODR system demonstrate a strong framework on embedded data security and privacy, both in design and daily administration. Okay, that's all. Hopefully what I had present is clear and useful for us. Thank you for your attention.
Thank you very much, Linda, for setting the stage and giving us a walkthrough of the ASEAN ODR guidelines. We'll now hear from other speakers who will give us update on the development of ODR in their respective member states. May I first invite Irene to give us the update on the development of ODR in the Philippines. Thank you.
Good day, everyone. It is an honor and pleasure to represent the Philippines in this regional cooperation activity relative to online dispute resolution, of course, upon invitation by the Hong Kong Department of Justice. I will briefly present the ODR experience and work in our country, including the legal and policy framework, current use of online solutions for ADR in the public and private sectors, international cooperation, of course, the challenges and solution prospects moving forward. Next slide, please. Republic Act number 9285, or the Philippine ADR law, encourages parties to resolve disputes outside of litigation and providing for the overall legal framework on the ADR in the country in accordance with international standards. Well, in principle, the various forms of ADR under the said law, such as mediation and arbitration, can be administered through online means. The said law also created our office, the Office for Alternative Dispute Resolution, or the OADR, an attached agency of the Philippine Department of Justice. It is mandated to promote, develop, and expand the use of ADR in the private and public sectors and assist the government to monitor, study, and evaluate the use of ADR by the said sectors, among others. In line with this mandate, our agency undertakes functions relative to training, advocacy, quality assurance, oversight, and policy development. Private institutions and public sector programs providing ADR services for administrative agencies are subject to accreditation by the OADR as the quality assurance mechanism relative to standards and procedures under the ADR law. The OADR can also appoint ADR neutrals upon the request of the parties. However, our agency as an institution cannot function or serve as an ADR neutral under the existing legal framework. And apart from its capacity building, quality assurance, promotion, and oversight functions, the OADR also cannot directly undertake the development and implementation of ADR programs of public and private institutions. The next slide, please. So under the current legal framework, several alternative dispute resolution systems are directly mandated by special laws, judicial rules, and administrative policies. We have the judicial ADR systems, we have the community-level public ADR program, or our barangay justice system, the smallest unit in our community. And of course, we have the construction industry arbitration, we have labor dispute resolution, and intergovernment dispute resolution. And we also have arbitration for intercorporate disputes and arbitration for government procurement contracts. Other alternative dispute resolution systems in the public sector are governed by administrative regulations of the concerned agencies, as well as the general procedures and standards under the ADR law. The next slide, please. Within the public sector, initiatives have been taken to adopt ODR. Mostly since the onset of the pandemic, video conferencing has been used in the judiciary and some dispute resolution systems that enabled sustained operation of the courts and administrative complaint management processes. Other application system-based online technology solutions have also been used by certain agencies for automated initial processing of complaints between consumers and financial service providers. The Philippine Department of Trade and Industry is in the design stage of an ODR system for consumer protection in line with the ASEAN guidelines. Then for the private sector, ODR systems for buyers and sellers are integrated in the major domestic and international third-party commerce application systems. Private alternative dispute resolution providers, for their part, have been conducting arbitration proceedings through video conferencing platform upon the request or agreement of the parties. The next slide, please. While there are some developments, there is currently no established legal and procedural requirements on ODR in our country. As seen in the past two slides, ODR is currently used as follows. Technology platforms, particularly video conferencing and application systems, simply facilitate the conduct of dispute resolution. And then we also have online solution support the established dispute resolution procedures in the public and private institutions, and service or ADR providers engage technology providers for online tools rather than end-to-end ODR solutions or services. Next slide, please. In the absence of established legal and procedural requirements specific to ODR, data security and privacy of dispute resolution and online solutions relative to personal information are governed by our Data Privacy Act, as administered by the National Privacy Commission. Specifically for the public sector, security of online solutions are governed by rules and regulations of the Department of Information and Communication Technology. The Alternative Dispute Resolution Act requires the observance of confidentiality in ADR proceedings and information, with or without the use of online technology solutions. Among the requirements for accreditation by our agency, the OADR, is the confidentiality of ADR processes administered by service providers. The next slide, please. The Philippines has been actively participating in international engagements relative to ADR and ODR. Our core multilateral engagements are with the UN, the United Nations Commission on International Trade Law, Association of Southeast Asian Nations, and Asia-Pacific Economic Cooperation. The ODR directions of our agencies are anchored on agreements and guidance from the said engagements. Our agency in particular is involved in certain bilateral engagements related to ADR and ODR, and we have an ongoing project in partnership with the European Union for a study of our governance framework on alternative dispute resolution, which includes the general policy on ODR. We also have official engagements with the Singapore Ministry of Law relative to international cooperation on alternative dispute resolution. The next slide, please. Right now, we have noted some challenges on the adoption and use of ODR, specifically for cross-border e-commerce. First, apart from the current regional cooperation guidelines and standards, there has yet to be a binding international legal regime that can assure continuity, predictability, accountability, and domestic enforceability of ODR. Second, apart from the Alternative Dispute Resolution Act, there is no domestic law specifically mandating the provision of necessary public sector funding and resources for ODR, providing standards for the development and use of ODR in the private sector. Third is the fast evolving communication online and e-commerce technologies that differ among countries and regions. Fourth is the limited availability of or access to domestic and international service providers specializing in ODR. And next slide, please. Moving forward, for the Philippines, the legislative proposal is currently in the Philippine Congress for the enactment of an Internet Transactions Law, which includes the development by the Department of Trade and Industry of an ODR platform. This is proposed to be a single point of entry for parties to domestic e-commerce transactions who seek out-of-court resolution of disputes when the private platforms or merchants fail to resolve or assist consumers with their concerns. While legislative work is ongoing, the Department of Trade and Industry is continuing its work in the development of a domestic ODR platform for consumer protection. And to facilitate the adoption and use of ODR in our country, our agency is working towards recognizing and promoting the use of ODR in the updating of the current Alternative Dispute Resolution Law. Participation in international cooperation for domestic and cross-border dispute resolution, including e-commerce, consumer protection, and trade facilitation, will be sustained by the government agencies concerned. Apart from the said government interventions, public and private sector collaboration on ODR will have to be pursued and sustained. This is to leverage on the expanding use of ODR in the fast-growing domestic and cross-border e-commerce platforms. I think that ends our presentation. On behalf of the Philippines and our agency, thank you for this opportunity to share our experience and work on ODR and be guided by regional development and directions and learn from the experience and best practices of our neighbors. Thank you.
Thank you very much, Irene. Now let's hear from Visit, who will share with us how Thailand built up the national ODR system by reference to the ASEAN ODR guidelines. Over to you, Visit.
Thank you for opportunities to present ODR system in Thailand. So I would like to share an idea on ODR in Thailand, servicing under THAC and link some idea with the Asian ODR guidelines. You may heard like THAC, we have stand for like Thailand Arbitration Centers. So we established by the act of the arbitration center, but the missions for the center is to promote all the ADR services. So for the first move to promote ADR in Thailand, so THAC try to moving fast for promote negotiations and mediations on dispute resolutions by online platform. So for the online platform that we launched on the 2016, it's called Top DD. This ODR system is not only the platform for the dispute party to just submit like a complaint, but it also like a working system for THAC staff. TalkDD has a good design of user interface and having term of use and proceeding, which is easy understanding by all kind of users. It can access by all devices. This all the thing is the key thing is for the accessibility keys according to the Asian ODR guidelines. So refer to the Asian ADR guidelines. It suggests that the first move for the ODR should be start on consumer. But THAC would like, we would like to make a fast move. So we just use TalkDD to provide services for the full range of commercial dispute in Thailand. So our missions that we believe it may be to encourage for the boost of the ODR is we need to encourage Thai people to understand well what is online dispute resolutions. So for many years, we try to produce video on general knowledge of ODR or produce publications and address seminar or just address for university student for competitions on the mediation and negotiation. So we believe that the new young generation will have a perceptions about how they resolve dispute by the ODR. The second point, we just encourage the other department in Thailand, just Department of Intellectual Properties and also Consumer Protections Committee to use the TalkDD for their service. Presently, the Consumer Protections Committee has launched their own ODR systems. I would like to move to the key thing that I would like to share for the key thing in this year for me is about the data and security and also privacy. We know that we have provide sufficiency security for the TalkDD, but right now Thailand also have Personal Data Protection Act and also National Data Privacy Act that require service provider to having a security measure according to the law. So I refer to the ASEAN guidelines. It suggests that the ODR service provider should have a low service price for the user to access for the ODR service. But to provide the security measure for such law, we have to spend more the budget to provide more the security measure to comply with the law. And so at this point, sometimes THAC also encourage their staff to do more responsibility to act as a compliance officer to create policy or provide measures to comply with the law. And so for the challenge of the arbitration, for the ODR in the Thailand. So I would like to share for the 2 points. I think for the legal enforcement is a key thing that the private sector in Thailand will consider on the first move on the ODR. Because many times I just have a concern from the a user when they consult about the process of ODR. They believe that anyway, if they cannot have legal enforcement immediately after they enter into the settlement agreements, they enjoy to go to the court. But the key thing is about the abroad legal enforcement. Right now, you may know we have Singapore conventions on mediations that a country who rectify this convention will have like a domestic law to recognize and enforcement for the settlement agreement that a party just like a success executes in their jurisdiction. So for the second point, I think right now refers to the Singapore Convention that I think is maybe just make a private business sector to have like an interesting more in the ODR system. So I think the point for the Thailand is we have to like to analyze what is pro and con and just to present to the legal committee in the step by step before the Thai government to just rectify and just issue the domestic law that would be take time around more than 1 year that or 2 years that maybe not make a Thailand to be the place for the ODR. And for cooperation that THAC has joined to try to bring more the ODR system in Thailand. So we have like be a delegate in the UNCITRAL working group that we have to report for the pro and con to the Thai government to know that what should be take the advantage from the mediations rules that are published by the UNCITRAL. In my conclusions, I think right now the world has changed to the digital economy. So there is 1,000 transactions every day. In the vice versa, there are a number of disputes every day too. So the ASEAN has a vision to have a one ODR system for all members to use as a one platform. And THAC also has important missions to promote the ODR and encourage Thai people to know more framework of ODR. Thank you. That is from my experience and sharing from THAC.
Thank you very much, Visit. Dung, may I now invite you to share with us the ODR pilot program conducted in Vietnam. Thank you.
Okay, good afternoon. So I think I need to see my slides up. Okay, while we are waiting for the slides, I think I'd like to thank the Hong Kong Department of Justice for the opportunity to speak today. I think I see my friend Dr. James Ding down there, so just want to say hello to him. I think my presentation, next slide please. Okay, in this presentation, I'm going to make use of the outcome from the project, namely projecting and promoting ODR in e-commerce for strengthened customer protection in Vietnam. This project was funded by the Australian Department of Foreign Affairs and Trade, DFAT, and managed by DT Global Proprietary Australia. And the project was implemented during March 2020 to September 2021, and by my institute, the Central Institute for Economic Management of Vietnam, in partnership with the International Economic Consulting, IEC, Vietnam International Arbitration Center, and Resolve Dispute Online, RDO in Australia. And the views and opinions here do not reflect those of DFAT, DT Global Australia, or the partners in this project. Next slide, please. As part of the background, I think Vietnam joined the discussion on ODR at the APEC very early. I think the discussion started back to 2016. In that period, we got a lot of active discussion with the Economic Committee of APEC. And at that time, I led the team in Vietnam in the APEC EC. And we were very eager to consider openly about the initiatives related to ODR. And at that time, we had very frank and open discussion within Vietnam with the domestic agencies and my ministry, the Ministry of Planning Investment, the Ministry of Industry and Trade, and Ministry of Justice, all agreed about the need to join these initiatives. But at that time, the contract enforcement was under the supreme authority of the Supreme Court, and when we consulted with them, they said we will be allowed to discuss about any initiatives that we want. We can do research, but we could not join the initiatives formally. And so when in 2019, at the time we had the endorsement of the APEC Economic Committee of the APEC Collaborative Framework on the dispute resolution of the cross-border business-to-business dispute. And at that time, I started to talk about to my domestic agencies about the need to have some sort of pilot ODR initiatives, and we were also lucky to receive a call for proposals from the DFAT with the funding to support the e-commerce aid for trade program. And at that time, we said in e-commerce there was some ODR platform already by the platform providers, but there are some sort of restrictions over there, and that's why we want to expand it to the ODR initiative in trade in general, not just in e-commerce. And we were lucky to get the approval for funding. And after that, in 2020, there was another changes in the e-commerce framework, when the decision by the Prime Minister also provides for the pilot implementation of ODR to support the dispute resolution of e-commerce. So they did not talk just about the facilitation of entry or the provisions of goods by e-commerce, but also about the easier resolution of disputes should they arise in the e-commerce environment. Next slide, please. And this is the figures that we had about the number of disputes reported by the Vietnam International Arbitration Center, which is the most popular arbitration center in Vietnam. And it was reported that before the COVID-19, the center had about 274 cases, and most of them were in the sales of goods, accounting for 40%, and some other areas such as provision of service, constructions, and things like that. In the past 2 years, the number of case load by VIAP remained rather stable. And last year, they report about 270 cases. But the share of the cases related to the sales of goods increased slightly to 44%. Next slide, please. And so in these projects, we designed several activities. First, we had a background research to take stock of what's being done and what needs to be done before we start the intervention by the project activities. And after that, we have identified several issues. We have identified several areas for capacity buildings. Then we started 3 training courses for the SMEs. These training courses were provided by my institute with VIAP, Resolve Dispute Online, and the International Economic Consulting. And we did not want the training to stop there. And then after that, we had some sort of like simulations and trials, meaning that we designed 60 cases of disputes covering different aspects, such as the dispute related to the intellectual property rights, in terms of the price, in terms of late deliveries, and things like that. And 30 of the cases were handled by the Vietnam International Arbitration Center, which is the ODR provider in Vietnam. And the other 30 cases were handled by the Resolve Dispute Online in Australia. And the CIM and the International Economic Consulting provide the legal and technical support for these ODR providers. After that, we had the simulation, the post-simulation surveys. So we asked the SME who joined the simulations to provide perspectives related to the experience, what they thought and what needs to be done afterward to improve the ODR popularity in Vietnam. And finally, we had several workshops with the mass media to disseminate the outcome of the project. Next, please. And before we start the intervention by the trainings and simulations, the survey at the beginning of the project showed that negotiation in Vietnam had been the most popular. And when we talk to the SMEs, they were very reluctant to talk about other cases of more formal ADR, such as the mediation or arbitrations. And the reason they said against the arbitration and the court is that first they would need the dedicated lawyers because they could not afford to have professional lawyers and so they fear that they would lose when going to the court anyway. But the second reason is more like a cultural issues. The firms believe that going to the court or the arbitration center is the last resort. They still feel that they need to talk to their partners, their suppliers, their buyers beforehand and try all the options they can before they go to the court or the arbitration center. But at that time, only 1/3 of the surveyed firm believed that the ODR would be applicable in Vietnam. Next slide, please. But after the series of activities, including the trainings, the simulations, and so the firms start to see that they had significant improvement in the awareness and the skills related to ODR. So you can see from the left-hand figure here, where the orange column shows the level of awareness and skills on ODR after the trials or simulations. And you could see that more business representatives shows that they have high or relatively high awareness and skills on ODR after the simulations. And when talking about the conditions needed for ODR applications in Vietnam, they have different perspectives related to the requirements on confidentiality, on the regulatory framework, on the human resource and technological infrastructures. And more interestingly, when the business representatives tend to think that confidentiality and regulatory framework are more likely to be a bigger burden for them when applying for the ODR platform, and the human resource and technological infrastructures may be less of an issue. Next slide, please. So when we talk about the key requirements for the ODR, next please. We had the set of the requirements there, and so the people show that, forward please. Then we have the different series of requirements. The first thing is the economic requirements. We need the level of transactions in Vietnam to be high, and in order to create enough demand for the ODR service. And there is also a need for the legal requirements, including the laws, including the norms related to the operations of the ODR. And in fact, we only have a government decree on the mediations back in 2018, but there are a number of other regulations related to e-commerce and to ODR that need to be improved. And certainly there are other requirements related to IT infrastructures and human resource that need to be dealt with. Next slide, please. And so I think looking forward, ODR is very important, but we don't want to keep it within the country. international cooperation is very important, and I think there are several perspectives related to that. The project has demonstrated that we can benefit from the shared knowledge and experience from advanced partners. And secondly, we don't just learn from the shared knowledge, we also work together for the pilot and voluntary platforms. And then, and in that perspective, the APEC EC platform can be important with the role in popularizing the APEC collaborative framework on ODR. And finally, we also need to work unilaterally or multilaterally to harmonize the related legal and technical standards for the ODR. And I think our earlier speakers also share different perspectives within ASEAN and APEC on that. And I think I thank you for the attention. I look forward to a discussion.
Thank you very much, Jung. Now let's hear recent updates from IBRAM International Online Dispute Resolution Center. IBRAM is non-profit, a law tech center and ODR institutions. IBRAM's IT team designs and manages the operation of all of its ODR platforms, and its secretariat administers the ODR cases conducted under its procedural rules. IBRAM has developed and launched an ODR platform to resolve low-value cross-border business-to-business disputes between companies, in particular micro, small, medium-sized enterprises, MSMEs, in APEC and beyond. And in May 2022, IBRAM was officially listed by APEC as one of the first batch of ODR service providers under the APEC collaborative framework for ODR. Now let's take a look at the ODR platform designed and set up by IBRAM.
Are you involved in a dispute, or do you see one on the horizon? Resolving your dispute by online dispute resolution under the IBRAM APEC rules and on the IBRAM platform helps streamline the dispute resolution process, significantly reducing time and costs. The entire process is fully digital, safe and secured, so that you can resolve your dispute from anywhere in the world. The process under the IBRAM APEC rules adopts an online, expedited, three-stage proceeding, that is, negotiation, mediation, and arbitration. Parties shall first commence online negotiation proceedings within 10 days. If the parties can't settle, a neutral will be appointed by IBRAM to mediate the dispute. From the appointment of the neutral, the parties will have 10 days to reach a settlement agreement. Failing a settlement of the dispute, the proceedings will move to the arbitration stage, which will take around 20 days until an arbitral award is issued. To reach conclusion, the whole process will only take 2.5 to 7 weeks. To start a case, you can create an account by registering with your email. To protect users' privacy, a verification code will be sent to users every time they log in. After agreeing to the terms and conditions, you may start filling in the e-claim form with information of the claimant, the respondent, the case details, and the amount in dispute, and then upload the supporting documents. You will then need to verify your identity with the latest eKYC authentication technology. In compliance with the APEC ODR framework, the costs of the proceedings conducted under IBRAM's APEC rules are affordable. For disputes with an amount up to 775,000 Hong Kong dollars, no filing fee will be charged, and the neutrals fees are capped. To grasp the likely costs of a proceeding, you may use the cost calculator. For example, for a 600,000 Hong Kong dollar claim, the IBRAM administrative fee is 6,000 Hong Kong dollars, just 1% of the amount in dispute. At the mediation stage, the neutral will receive a fixed fee of 4,000 Hong Kong dollars, inclusive of preparation and up to 4 hours of mediation. Up to the arbitration stage, with the issuance of a final award, the neutral will receive a fixed fee of 10,000 Hong Kong dollars. EBRAM's APEC platform is a fully fledged online platform equipped with advanced digital technology that is quite unique. The communication box and document management tool enable parties and the neutral to exchange documents and communicate in a controlled environment to ensure privacy and data security. An inbuilt video conferencing system. Meetings and hearings can be arranged anytime through the platform with real-time transcription. Parties may use breakout rooms for private mediation sessions and a joint VC room for arbitration. Parties can use the calendar to schedule meetings and mark key events. During the arbitration stage, the neutral may set out a timetable for the arbitration proceedings after consulting the parties. With the timetable, parties may refer to the calendar for the relevant deadlines. Another key feature of EBRAM's platform is AI machine translation. Users may translate any documents in 5 languages: English, Chinese, in both traditional and simplified forms, Russian, Arabic, and Spanish. With EBRAM's e-signing system, parties can sign a settlement agreement directly on the platform. Cybersecurity and data privacy are our priorities. To protect the information and communications, parties may exchange confidential files securely on EBRAM's platform, without the need to use email or other less secure means. All data is encrypted during transmission and cloud storage. All users' accounts are protected using multi-factor authentication. EBRAM's platform is protected by the highest level of cloud security. Arbitral awards issued by EBRAM are enforceable in 170 jurisdictions under the New York Convention. Notably, a draft award prepared by the neutral shall be first submitted to EBRAM for scrutiny before it is finalized. This is to enhance the validity and enforceability of the award. An original award signed by the neutral will be sent to the parties by courier. A scanned copy will also be made available on the platform. EBRAM is one of the 6 qualified institutions under the Arrangement on Interim Measures between the People's Republic of China and the Hong Kong Special Administrative Region of the PRC. With this arrangement, parties to arbitration conducted on the ODR platform under EBRAM's APEC rules, with a seat of arbitration in Hong Kong, can apply to the mainland Chinese courts for interim relief against mainland-based counterparties. EBRAM is the first and only online dispute resolution services provider from Hong Kong listed under the APEC ODR Collaborative Framework. Our APEC ODR platform offers you an affordable, end-to-end digital experience in a secured environment to resolve cross-border disputes.
Thank you. So as you have just seen, EBRAM has developed a platform that aligns with the criteria set out in the ASEAN ODR guidelines, in particular with respect to data privacy and security, the legal and procedural requirements, and the use of modern technology. EBRAM provides businesses in ASEAN with an alternative online mechanism to resolve low-value disputes by ODR through a safe, convenient, and cost-effective ODR platform. Before we move to the next part of our session, next and final part, we would like to hear the development of ODR in Indonesia. Linda, may I please invite you to give us a brief update? Thank you.
Okay, thank you, Mr. Currently, the Ministry of Trade is developing national online system for consumer complaints. integrated with some ministries and institutions. The system will be a forerunner of the national ODR system. The development of ODR system in Indonesia was initiated to respond to and take advantage of the increasing use of digital technology in various aspects of life, including trading activities. This system is expected to make it easier for consumers to submit complaints and can expand to reach of consumer complaint services to remote areas of the country. We take the Brazilian ODR system as a benchmark, with some various adjustments take into account the Indonesian context. The development of Indonesian ODR system will be carried out in some steps, where currently the focus in developing of the national online system for consumer complaints. The system was initiated in 2020. In 2021, its design and business process were developed. In 2022, the design and business process are finalized based on discussion and coordination with some ministries and institutions and experts. In 2023, the system development will be conducted, starting with national online system for consumer complaints. This system is designed to make easier for consumers to file complaints and also for businesses to respond them. With the system, there will be a national database of consumer protection. So now Indonesia doesn't have the national database. It's the ministry and the institution has the database, the consumer complaints, but we don't have the national database. So that's why we developed the ODR national system. This system is expected to facilitate the resolve of most consumer complaints properly, so that the number of disputes can be reduced. Okay, thank you, Mr.
Thank you, Linda. We will now move to the panel discussion, perhaps starting with you, Visit. In your presentation, you mentioned the system Talk DD developed by, or provided by the Thailand Arbitration Center. Could you share with us how often this system has been used and if you have encountered any challenges in promoting it? Thank you.
So for the numbers of the user who just join to the Talk DD is around 10 cases per year. But I think if I just search in the Consumer Protections Committee, I understand that there is a huge number for about the consumer dispute. But I think it's maybe more than 100 cases in the ODR. But for the challenge to promote ODR in Thailand, I think it's about the perceptions of a dispute party, because the ODR is one of the a kind of alternative dispute resolution, which depends on voluntary of the party to join the sessions to find the solutions for settlement agreements. So as I mentioned, the THAC try to encourage a new young generation to understand that we have not only the one-way dispute resolution in the litigations. That's on my side.
Thank you, Visit. And do parties have to stipulate an ODR clause in their agreement in order to use ODR to resolve the dispute?
In Thailand law mechanism, there is no requirement to require a party to stipulate ODR clause in their agreement. But I believe it may be good if a party just stipulate the clause in their agreement, because as you know that this process are like kind of the ADR, and a party needs like a background to encourage the opposite party to join the ODRs. So I think it may be good if the party just stipulate the clause in an agreement.
Thank you, Visit. Zung, I would like to ask you the same question. Regarding the ODR pilot program conducted in Vietnam, how can SMEs use ODR to resolve their disputes? Are there any requirements?
I think in the presentation I mentioned that the cases were designed beforehand. It's not they were not actual cases, but we also made use of the platform that was introduced by the Vietnam International Arbitration Center in March 2020, and at that time they were using the the mediation app online. So it focused only on mediation, and there was no online platform for arbitration and things like that. But at that time, I think, and to the best of my knowledge, when we talk about the VF, I think that there was no requirement to make explicitly that we need the ODR platform. So people can either refer to the on the need in the clause to resort to the Vietnam International Arbitration Center when we have a dispute, or they can refer to the general dispute resolution measures, and then afterward, when dispute arises, they can work together. And when they agreed on the need to settle the dispute at the VIAC, then online mediation can become an option there.
Okay, thank you. Is the ODR system envisaged to be gradually expanded to other sector or industry?
I believe this is going to be a new trend in Vietnam. I think there are several reasons for this. First, on the demand side, the SMEs start to have more disputes in the COVID context, and they start to see that they can't go overseas, they can't travel even within the countries across the region just to settle, to meet their partners and settle some of the disputes that may not be financially worth. And so they see the need for the ODR there. But on the supply side, the Vietnam International Arbitration Center also faced some competition from other private ODR providers in Vietnam. And so, for example, they have the Hanoi International Arbitration Center, not so popular in Vietnam yet, and still quite young center. But they were set up by some guy working formerly in the Ministry of Justice, and she knows about the things related to ODR, and she could offer more modern practice and more focused one. And that is one example of the competition. And so Vietnam International Arbitration still have to improve a lot in terms of the technologies, in terms of the procedures they can offer, and also in terms of the cost that they have to work on that. And finally, in terms of at the policy level, there is a broad direction of policies and institutions in Vietnam to promote the virtual hearings and things related to that. The Supreme Court also got the note from the leaders in order to carry out the pilot virtual hearings. And also in terms of the policies, like I mentioned, we also have the Prime Minister decision to allow for the pilot ODRs. And so when people see more demonstrated benefits from that, I think we go not only across the borders, not only across the sectors and industries, but also across the borders with other partners in the regions.
Thank you, Dung. Now turning to you, Irene, what is the policy direction of the current administration in relation to ADR? And are there any plans to promote ODR? Thank you.
Yes, of course. There are plans to promote ODR in the Philippines. Actually, we have started promoting ODR here, and we have our agency particularly held a lot of webinars and seminars on this. And to inform everyone, since we have this engagement with the European Union, they're helping us on the revision of our ADR law. We're planning to codify the scattered laws with all the other industries and areas to and make it into a code, and that will include also ODR guidelines and policies, so that we can lay down the foundation for what the Department of Trade and Industry will also be doing. So we're simultaneously doing these things right now for ADR and particularly for ODR. Thank you.
Thank you, Irene. One of the objectives of the ASEAN ODR guidelines is to ensure the development of a unified ASEAN member states ODR system sharing the same considerations. This will enable the national ODR system to be interlinked and form what we'll call an ASEAN ODR network. Linda, what are the challenges for establishing the ASEAN ODR network, and what would be the solutions?
Okay, thank you, Mr. Yeah, we have some the challenges to develop the ASEAN ODR system, such as the differences of understanding about the concept of ODR system among the AMS, and then the limited the institutional or human resources capacity in ASEAN, and multilingual in ASEAN, and then regulatory constraints. For the differences in understanding and the limited of institutional or human resources capacity, we can improve by the capacity building and discussion among the ASEAN member states. For the constraint of the regulatory, the IMS should to the revise their regulations about the system, the national ODR and ASEAN ODR system. Okay, that's all. Thank you.
Thank you, Linda. And if not all member states can complete their national ODR system by 2025, how will the ASEAN ODR network be implemented?
That's not be stated in the ASEAN ODR guidelines, but in the feasibility study, that stated the ASEAN ODR system will be started anytime, at least 2 MS ready for the implement. What's your question?
The ASEAN ODR network. If
Yeah.
not all member states have...
but my personal view, if the integration about the national ODR system into the ASEAN ODR system, we can to discuss among the ASEAN member states. So we should support each other. Thank you.
Okay, thank you very much. We have come to the end of our session. I would like to thank our speakers, Linda and then Dung, Visit and Irene, and thank you all for joining this session. Thank you.
Thank you.
Thank you.
I think we are very focused, that's why. Thank you, Ms. Ta, for the ODR platform demonstration, and Ms. Sally, Ms. Alogok, Mr. Dong, and Mr. Sali Watanapana for the very inspirational sharing and discussion. So please stay for a group photo. So remember to smile. Also include our online ones if they wish. Okay, so let's continue. All right, thank you very much. Please take a seat. Let's give them a round of applause as well. Thank you. Before we move to the fourth panel session, there will be a break of around 15 minutes. So our last session will begin at 3:30 Hong Kong time. So please be seated 2 minutes before 3:30. Thank you. Ladies and gentlemen, our session is about to start, so please be seated. Thank you. Ladies and gentlemen, welcome back. Here comes to our fourth and final panel session. And the topic will be encouraging greater participation in ODR and capacity building. We are delighted to have Dr. James Ding as our moderator, Mr. Nicholas Losada Pimiento, Professor Yoshihisa Hayakawa, and Mr. Nick Chen, MXJP, as speakers. Dr. Ding is the Law Officer, International Law of the Department of Justice of the Hong Kong Special Administrative Region of the People's Republic of China. Dr. Ding, time to you.
Thank you. Good afternoon. We are now coming to the final sessions of today's workshop. I think it's a very good workshop. It's the second phase of the APEC, the ASEAN ODR workshop. And last time we can only have it online, but this time we can welcome a number of participants from ASEAN member countries. So it's really successful. And on this panel, we'll discuss about encouraging greater participation in ODR and capacity building. And we have a panel of three very distinguished speakers. First, we will have Professor Nicholas. He's a lawyer in Colombia and also a CEO of two startups based on ODR-based startups. And he also teaches at the university in Colombia. And he would give us an overview of the ODR development and also how to encourage greater participations in the use of ODR. Our second speaker is someone that we probably know because he also participates in many workshops and seminars on ODR, Professor Hayakawa. He is professor at Nikko University in Tokyo, and he is also the representative of Japan to many international organizations and meetings, including APEC, UNCITRAL, UNITRAL, etc. And he is also the Secretary General and Executive Director of the Japan International Dispute Resolution Center. He will take us through some of the international developments on ODR and how the improved legal environments internationally can help to encourage greater use of ODR. Our last but not least speaker is Mr. Nick Chen, our director of the ELCO Hong Kong Regional Arbitration Center. He's joining us in person here, and he will also take us through about the very recent establishment of the ELCO Center in Hong Kong, just opened in May this year, and the ODR service provided by the center, and how the center is working towards encouraging greater use of the ODR. So without further ado, may I now invite our first speaker, Nicholas. I know it's very early in the morning for you in Colombia. Thank you for joining us online. So the floor is yours, Nicholas.
Thank you very much. Firstly, thank you very much for having me here. Yeah, it's kind of early in the morning. It's 2 in the morning here, but I'm very happy to share some of the experiences on how to encourage ODR, more so coming from a developing country like Colombia, who's not that used to to the implementation of technological tools in justice in general, but in dispute resolution in particular. So it's been a challenge to me for the last few years. I managed to meet Professor Hakayawa just more than 10 years ago when we were both delegates at ANCITRO. And for me, coming from Colombia, it's been always a challenge to see how to have more of this applied in my country. After many years just discussing and having more academic approach to the topic of ODR, I started to implement it with a startup. And this startup is, Redec is ODR based, as you mentioned, and it's how to make this real, or how to make it in concrete terms. So what I'm going to discuss today is, so first a brief introduction on why is this relevant, then how the international standards on ODR are the foundation to its proper encouraging. Then some encouraging scenarios that I found particularly applied in Colombia, and the way I think they can be applied worldwide, and finally a brief conclusion. So cross-border transactions have increased over time, more so after the pandemic. So just from 2020 onwards, we have an increase of over 20% on its use. So you have more and more people using e-commerce, and particularly cross-border transactions. So it's fundamental to have those disputes, the disputes that arise from e-commerce, to be also resolved on the internet with the internet logic. So that there's a need for ODR because people use internet more and more. So for instance, the European ODR platform for commerce disputes, they had this in 2019, they had just 2.3 million visitors and then in 2020 that increased to 3.3 million. So it increased severely in a few years. And then the investment, for instance, that goes for ODR has also increased from 210 millions to over 500. That's the expectation for the next following years. And the emerging markets where ODR is not applied as much are Latin America, Asia, Africa, and the Middle East. So particularly in Latin America, that's the region I'm from, there's a huge potential for ODR because it's not as applied as it should be. It's only applied by a few internet-based companies and basically by e-commerce apps, and how we can make this accepted or embraced by the majority of the population. So that brings me to the second part of the presentation, and the way you can have people accepting ODRs in general, and that's the premise, the basis of anything or any scenario that I will mention afterwards, is with the international standards. We have the iCoder, we have the technical notes that were also developed by ANCITRO, and the work that it's been developed by particular centers such as the ICDR, the American Bar Association, and all of them point to the need to have fairness, due process, transparency, accountability. So the better your ODR platform is, the more use it's going to get. And situation that we can present in Latin America and also in Colombia is Mercado Libre, which used to be an e-commerce platform on its own, like a Latin American-based e-commerce platform. Now it's part of eBay, and it's taking most of the international standards that eBay applies in its ODR platform. This is now called Empodera, and it's presented as a separate platform from Mercado Libre as such. So that points out to the impartiality, but also as to higher standards on data security, effectiveness, or participation. So you're getting more sophisticated platforms because they embrace the principles and the standards of ODR. So then taking that as a basis, so you have to develop very good platforms, and that will get people to use ODR. But then how should we encourage the use of ODR worldwide? So these are 6 scenarios that we've been working on in Colombia, particularly with Redec, with the company I'm leading, and that I think it could also be used as an example for other markets. But the first one is tailor-made solutions applied to companies that want to have ODR. The second one is the legal clinics, so to have students, law students, applying ODR as part of the daily job. Then you have arbitration as well, so how you can promote an arbitration, how you can apply it in public agencies, how you can apply it in general for justice, like ODR as a standard for justice, and finally, how can you reach ODR? So let's get into each of them. So the first one, the tailor-made solutions. So what I found out, and the reason why many, say, banks or many big companies in Colombia don't use ODR is because they feel that there's no specific ODR that can fit their needs. So what we've been working on with Redec is they have their own needs, and we cannot just have just one general platform that can be applied to all, but tailor-made solutions. So for instance, this is what we're doing with the Energy Group of Bogotá, Grupo de Energía de Bogotá, which is a conglomerate of companies involved in the energy sector, not only in Colombia, but also in Latin America. And this proposal involves not only the dispute resolution as such, but a platform that can also lead to contingency and litigation administration. So the ODR, the dispute resolution, may very well apply to disputes arising, but there's also a very good tool to know contingencies, so that will help them prevent disputes and then to manage their current litigation, because there's litigation anyway, and that's outside the platform, but can be managed through the platform with case management and with a final or with a view of fully implementing ODR. And with that, what the Energy Group of Bogotá wants to achieve is to have a repository of documents. So all of the documents that involve their operation and that are related to dispute resolution can be managed through one platform. So the ODR platform becomes more sophisticated with the use also of artificial intelligence, and it really fits the needs of the Energy Group of Bogotá. So the more you can present companies with tailor-made solutions that involve ODR, they will be more willing to adopt it as their standard. The second one is with legal clinics. So legal clinics, and what we have is, why shouldn't we promote the use of ODR at universities? So in Colombia, and as it's also the case in many other countries, including the United States and some European countries, so there's free legal services provided by law students under the supervision of law professors. And the proposal we have, due to also recent legislation reform in Colombia, is the adoption of ODR platforms for their students to manage their cases. So basically, the idea is to have future lawyers using ODR platforms for the day-to-day work under the supervision of professors. So we have proposals in several universities, not only in Bogota, but in the coast of Colombia, Universidad del Norte University, and Universidad de San Buenaventura. So that's so those are what we want to do, is to have the massive use also for low-income users. Those are the users that will have resort to a legal clinic. Secondly, we have also what we call the humanization of justice, or the humanization of ODR. There is a digital divide that affects particularly Colombia. Of, I would say, more than 30% of the population do not have access to proper technological tools and computers and internet access. So we want to break the digital divide. We want to overcome the digital divide, and we have come up with the idea of a REDEC advocate. So it's also using humans to help users who don't have access to internet or to technology to use them. So for instance, if I can call someone and that someone will use the platform for me, that will be the idea of an advocate, not necessarily a lawyer, but someone who can really help people to use technological tools if they don't know enough or they're not using them in the way they should. Also, we have the public agencies. So we've been working with public agencies in Colombia for them to adopt ODR for their dispute resolution needs. We implemented a pilot with the Office of the Attorney General of Colombia for civil mediation with very successful results, and even having public officers who've been using for many years paper-based solutions to use a platform. And also the modernization of ODR platforms. We have one that's also public and it's been for a few years, since 2015 in place, which is called SIC Facilita by the Superintendency of Industry and Commerce, which is the consumer authority in Colombia. Along with the Chamber of Commerce of Bogota, we're doing consulting work for them to improve their own platform and to have them used by more people. And also with the use of arbitration, with the legislation reforms of in 2022, and taking into account what's happening in the current legislation, Law 1563 of 2012, we want to promote the use of ODR in general, but also the use of ODR in fields that it's not often used, for instance, for arbitration. So not going only also for consumer disputes, but beyond consumer disputes. So for instance, we have the draft law 584 of 2021. So as a general legislation promotion under international standards of ODR for mediation, but also arbitration or prediction or prevention. So broader use of ODR, not just limited to mediation as is usually the case. And finally, justice. So we have seen with the pandemic the need for digital justice, and some courts in Colombia, starting with the Council of State, so the highest administrative court in Colombia, is adopting platforms that aim to achieve the standards of ODR. They have many of the functionalities. Perhaps it's not as user-friendly as you would. It basically takes into account the paper-based procedure and adapts it to a technology. So there's room for improvement, but there is a progress being made in terms of how people can consult the digital files. They can see, get notifications. They can interact with judges. They can submit they can make their submissions also online. So if you can have the judicial branch, the judiciary, applying ODR, for instance, just for something as simple as to look into existing procedures, you are having a progress. And if you can have the judiciary applying the ODR standards, as Richard Susskind says, you are having more and more people embracing this idea. So in conclusion, I believe that the ODR should look for people, not just, I really don't agree with platforms that are just there and are expecting for people to go and grab them. The ODR platforms should start to adapt themselves to what people need. And then, and we should apply to many areas of people's lives, for instance, to the education, legal clinics, to justice in general, as online courts, also for e-commerce, of course, but for many other areas in life, arbitration, for instance. And then finally, not only think of this as a private solution, only related to commerce, but also to public disputes. So for any needs in dispute prevention, resolution, or legal health in general, you can have ODR. So, and I would like to have this quote: if the mountain won't go to Muhammad, then Muhammad must come to the mountain. And in this case, if the people won't go to ODR, then ODR should come to the people. So that will be it. Thank you very, very much.
Thank you, Nicholas. I like the last quote in your last line. Yes, I think that we should not just wait for the business to go to ODR, but we must find ways to bring ODR for the businesses. And thank you for sharing the experience on how to encourage greater use of ODR in Colombia. Like in Latin America, in ASEAN, and in this part of the region, there are also many emerging markets and also very varying level of developments. So I think that the lessons we learned from Colombia may also be equally applicable in this part of the region. Our next speaker is Yoshi. Yoshi is online. We know him very well, so he will share with us some of the latest international developments concerning the international ODR framework and also related developments in ISO as well. So Yoshi, the floor is yours.
Thank you very much, James. Can you hear me?
Yes.
Thank you. And I'm trying to move my slides by myself and just wait. How can I do it? Okay. So in my presentation, I'd like to explain the recent progress of the international framework as this order. So the first, I'd like to explain about the increasing demand for ODR. So of course, everyone knows about e-commerce has drastically increased worldwide, and wide use of e-commerce has increased automatically. The number of related disputes, including cross-border ones, in the online shopping, and at the same time, average of the order value of consumers is approximately more or less $50. It means if someone in trouble, the person has to, for example, bring a litigation for only $50 disputes. And if the case is cross-border ones, the person has to bring a lawsuit, cross-border international lawsuit, only for the $50. Of course, it does not make sense. So most of the cases, people have to give up for the $50 or something like that. So at the time of dispute, litigation or traditional alternative dispute resolutions, ADR, cannot substantially resolve the disputes, especially cross-border ones. The ADR system using online, which is called ODR or online dispute resolution, was an easy and speedy dispute resolution, have been gradually and widely used for e-commerce related disputes until now. For the harmonization of ODR schemes and for the smooth introduction of ODR systems in the emerging market countries, international organizations have issued or started to examine international legal instruments or frameworks or ODR. So I have just come back from Africa, the country of Senegal, where Congress of International Lawyers Association was held. And I made several presentations, including this ODR issue. But I was very surprised and impressed because many African people have a great interest on the use of ODR in their disputes. So, sometimes it is very difficult to introduce such a advanced technology-based dispute resolution system. But if we have a legal framework or standard framework for the ODR, so such a introduction of the ODR system would be very smooth for emerging market countries. And as I explained later, so in the APEC project, many ASEAN member countries have a great interest and they are actively involved in the project. So let me show the present legal instruments about the ODR. The first one is the United Nations Ancestral Technical Notes on ODR, which was started 2010 and which finished 2016. And another one is the Model Procedure Rules for the APEC Collaborative Framework for ODR of cross-border B2B disputes. And this project started in 2017 and still continue even at present. And ISO TC321 project, Transparency Assurance in E-commerce project, which including ODR sub-project, which has just started, and I will explain these issues. So first of all, APEC ODR project after the ancestral ODR project, what does it mean? So the ancestral, United Nations Ancestral Technical Note on Online Dispute Resolution, and this is the one of the frameworks for the ODR. But at the very beginning of the project in 2010, United Nations online arbitration rules were tried to establish. And at the very beginning stage, we tried to establish a rule where a single arbitrator chosen by ODR administrator, and because I know that we need a very quick and speed and efficient process. And second concept is that all awards shall or should be in public on website except private informations. So we are now examining the use of AI in the ODR systems, but AI needs big data, and this kind of the big data of the awards will be very useful for the the use of AI in the near future. And we are trying to establish a substantial enforcement system by trust mark, because if the lose party, a defeated party, do not voluntarily obey the final decision, but we need a kind of the enforcement process. But if we try to use a judicial enforcement system, of course it will cost. So we have to establish the substantial enforcement system by trust mark. And trust mark means that is a kind of the symbol, and the e-commerce vendor clearly declares, I will follow the final decision after the ODR process. So the customers, including consumer, can easily find which e-commerce vendor is a reliable and credible one. So the trust mark works like that. And at the very beginning stage of this UN project, we try to establish this. And most ambitious one is the worldwide uniform rules for the merits should be established. Because I'm a professor of private international law, but honestly speaking, such a private international law issue or governing law issue is the most difficult and cost-consuming problem. So, but if we could establish somehow substantive rules for the merit for the ODR decision, so the process for the ODR could be very simple. But unfortunately, the United Nations project is facing deadlock because gradually a serious issue appeared. That is the validity of the pre-dispute arbitration agreement between a consumer and business corporation. So the US and other countries said, of course, it should be valid. But EU, Japan, and other countries, consumers should have a cancel right. So according to the regulation in EU or other countries' regulations for consumer protections, since a consumer should not be removed its right to go to court, the consumer shall have a right to cancel the pre-dispute arbitration agreement. And the ADR Directive EU and ODR Regulation EU was established according to this direction. But as I said, the United States and other countries have a different policy. So two different policies for the consumer protection or the pre-dispute arbitration agreement treatment of the pre-dispute arbitration agreement was seriously discussed in the rule-making process of ODR in United Nations. And finally, we gave up to establish model rules for ODR. And the ancillary technical notes on ODR was issued as the kind of the byproducts. So which have no legal effect, and it encourages 3 steps. First one is the negotiation, and the second one is the mediation, and the third one in the kind of the decision-making process. But there is no explanation about the third steps, especially the third step could have a binding effect or not. So since the rule to be established there were model private rules with no overriding effect to the regulation of each state, we should have compromised and created more substantial model rules at UNCITRAL. So based on this failure, APEC started its project. APEC model procedure rule on ODR of cross-border B2B disputes. So the EU is now establishing its own ODR platform, and it works. But other states still need uniform rules and schemes for the global ODR platform with negotiation and the third parties' interventions. So APEC started the project to establish another global ODR platform, and UNCITRAL and UNIDROIT assist the APEC project of ODR. And based on our failure in United Nations, B2C issues were avoided, at least at the very beginning stage. So APEC will not work as a provider of the ODR platform. Instead, APEC will encourage members to collaborate for the wide use of ODR and provide model procedure rules and encourage many ODR providers to be listed as the APEC satellite website. So now document of APEC collaborative framework on ODR and APEC model procedure rules on ODR has been approved, and but it is substantially same as the final draft on model procedure rules of UNCITRAL. So the UNCITRAL now still alive in APEC documents. So APEC collaborative framework on ODR aims to assist member states to encourage the wide use of ODR in its jurisdiction and to assist business corporations, including e-commerce market providers, to actively use ODR in the APEC region. And academic institutions, which is called leader academics in the APEC region, jointly assist to maintain a website on the satellite website of APEC, where ODR providers adapting APEC model procedure rules on ODR are listed. So the CTAC from China and the Guangzhou Arbitration Commission from China and the EBRAM from Hong Kong, China are listed now. And I'm wondering, whether or not, the newcomer will be listed from Hong Kong. I'm very expecting. And additionally, perhaps, the sooner, immediately, one Japanese ODR provider and American provider will be listed. So the ODR provider on the list are regularly monitored by Leader Academics, and it is a kind of the trust mark for the credible ODR providers. And this is the ODR in the project website. And please check www.apec.org/SELI, SELI. And finally, I'd like to show you about the new project. The APEC project is a kind of the regional project, but we need a much more worldwide one. And the project for TC321, which was proposed by China, is now have a ODR project. So Japan proposed to use this ISO standards as a trust mark for the implementation of a settlement achieved in the scheme of ODR. So consumers, including customers, including consumers, can easily know a good e-commerce vendor with the ISO mark, which means the vendor promised to provide ODR systems for companies, complaints from customers, and to obey a settlement achieved in the ODR scheme. So we are now establishing basic principles, technical conditions, and operational manuals on ODR. They are expected to be established as one of the ISO standards, perhaps next year. So the working group 3 of the ISO is just, about to start its project, its, the operation. So I'm very, excited about this new project. So thank you very much. This is at the end of my presentation.
Thank you, Yoshi. As Yoshi has explained, the use of ODR is indeed an international trend, especially in this part of the world and the APEC as well. And now we see some encouraging development under ISO as well. So ODR will be a very useful means of resolving disputes for the businesses in particular. Our last speaker is Mr. Nick Chen. Nick will take us through of some of the work we have been doing under the ELCO Hong Kong Regional Arbitration Center, because I understand that the center is dedicated to promoting the use of ODR. So the floor is yours, Nick.
Dr. Ding, Your Excellencies, Consul Generals, friends, and my new glass of water. Thank you for joining us today. I'm grateful for DOJ for allowing ELCO Hong Kong Regional Arbitration Center to come and do some sharing. Thank you. Now, Consul Generals in the room would be very familiar with ELCO, but for our friends who are joining us online, I hear 1,000 of us are joining online. ELCO stands for Asian African Legal Consultative Organization. The organization was established in 1956. It has 47 member states. So think of it as it is an intergovernmental organization. It's established by international law. And, it represents 2/3 of the world's population, and the recent GDP, combined GDP is at $26 trillion US. So it represents a lot of opportunities. A lot of doors can be opened if businesses work with ELCO. ELCO in the 1970s have decided, as ELCO help the world solve a lot of problems and share their ideas, including through a seat on the UN, it's decided to have an international dispute settlement system. To date, it has set up 6 international arbitration centers. Most of the arbitration centers do more than just arbitration. So when you see the name arbitration, of course, bear in mind, we're also very supportive of mediation first. These are my logos of my fellow friends. The 5 other dispute arbitration centers within the ELCO dispute settlement system. They are in Nigeria, Iran, Kenya, Malaysia, and Have I missed anyone? Yeah, Egypt, of course. So we work closely together, and we work with other arbitration centers as well. So we complement the other arbitration centers, dispute resolution centers, mediation centers, conciliation centers you have been working with and gotten to know. But I think one of the key difference here is that it is the ELCO Hong Kong Regional Arbitration Center in Hong Kong, like many consul offices, embassies, it's been accorded special status. It's established by international law. We don't have a business registration certificate issued by the Hong Kong government, which also means we are not directly regulated in some ways. Our documents are inviolable, which means it's super country neutral. So we welcome businesses, governments, when they have disputes, international commercial disputes, please come to us. We're here to help. Not only do we provide a state-of-the-art dispute resolution, online dispute resolution platform, we do it in a way that we can guarantee the documents are protected, and we are impartial and country neutral. And I should say, perhaps, if you're listening, if you're representing your country or listening from other parts of the world, we are inviting experienced arbitrators to join us and to be on our panel and committees. And we want to stay true to our mission to be open and inclusive. So our key objective is, of course, to help people thrive and succeed, as the representative from UNITRO have mentioned. By having a good system to resolve disputes, there will be more business. There will be, economy is the bloodline of many, countries, and we're here to help. Now, like our friends from other ELCO centers, we provide all sorts of dispute resolution, but in particular, we're here to champion ODR. So hence, I'm on this panel. Our center opened on May 25th, early this year. Thank you for some of the friends who are in this room who came for our opening. We have the support of other dispute resolution centers, consul generals, the two legal professions in Hong Kong. So thank you. We continue to here to build, working relationship. We'll be exploring to enter into a number of MOUs now. So this is a good time. I'll be reaching out to you for your help, and we could work closely together. I have to, of course, thank the Hong Kong government and the central government for their support, for supporting us in the sense of allowing us to use a beautiful office at Legal Hub number 3, right in the heart of Central. So businesses are welcome to come, borrow, use our center. We have state-of-the-art facilities. LawTech are us, ODR are us, and Hong Kong have a lot of excellent, unique advantages for people to come here to resolve their disputes. We support both institutional dispute and ad hoc disputes resolution. Take advantage of the 15,000 odd strong, 15,000 strong legal professionals in Hong Kong, and great law schools in Hong Kong who are working with us. And by working in Hong Kong or working through Hong Kong as your base of operation, you can easily reach the 1.4 billion huge market in mainland China, and as well as the Greater Bay Area with 11 cities, including Hong Kong. And RCEP, you heard from our SJ earlier today as well. On the screen, I'll invite you to take a photo if you have your camera with you. This is our dispute resolution clause, our model arbitration clause. The words in bold, it's all you need to activate us, to allow us to help you. So when you enter into a contract, in the past, as a practicing lawyer myself as well, I've seen often the parties would negotiate over, well, unless you give me this, I won't sign the contract. This is one of those clauses. dispute resolution. If you enter into a contract to invest a lot of your money in another country, are you prepared to use their courts, however neutral or however a professional you perceive them to be? Or would you prefer a third party, neutral? So we offer that here. So if you come to us by putting that clause into your contract, or when disputes arise, if you choose, as parties, well, let's not go to courts, it's expensive, it takes a long time. Enforceability sometimes could be an issue if you're trying to enforce a court decision in other countries. Why not put this into your contract? The words that are not bolded below are optional. So you're welcome to, for example, designate, I only want one, a single panel arbitrator, so that it's less people involved, maybe more cost effective. So to answer Yoshi's earlier question, I hope we could be admitted into the APEC ODR framework soon. For now, we couldn't because we haven't yet promoted our mediation clause out there yet, but we're working towards the direction. We're expecting soon if you use our center, you'll be able to soon be able to take advantage of the special arrangement reached between the Hong Kong government and the central government, whereby if you started an arbitration elsewhere outside of Greater China today, you cannot go to the mainland Chinese courts to apply for injunctive relief to protect assets you want to go after, protect the evidence you need to deliver justice. Now, but if you were to do it in Hong Kong, in one of the approved centers, and we are applying to become one, once you start a case with us, you can go to the mainland Chinese courts and apply injunctive relief. So this is a super big plus. Now, of course, the lawyers who qualified in many jurisdictions, lived in many countries and speak many languages, it's a huge plus as well. Please come experience our ELCO advantage. I'm sure there are things we could do more by working with you. Our ELCO Hong Kong Regional Arbitration Center Online Dispute Resolution Center has gone live. You've heard from Emmanuel, CEO of IBRAM, where I used to serve as the chairman. You've heard this wonderful IBRAM ODR platform developed locally by IBRAM. Well done. We are powered by IBRAM. So our ODR platform is powered by IBRAM. So we also enjoy the many unique advantages you've heard just now. So welcome you to go to our website and Google us, try us out, and see how we can assist and help. You've had many other advantages, so I'll save a bit of time about ODR generally. Finally, I just want to talk about capacity building. It's imperative for every country, every nation, every dispute resolution center, in fact, to help with capacity building, to develop more experienced dispute resolvers. As lawyers, I feel like we are born natural problem solvers. But as you know, arbitrators are not all from the same profession. We welcome people from other professions to come get trained up. So we have training sessions. I expect our ELCO Hong Kong Regional Arbitration Center to be inviting members of ELCO, 47 countries, comprised of most of the countries in Asia and Africa, to send their best, or up and coming, or the judges, arbitrators to come and exchange and learn. That has happened before in Hong Kong, thanks to the Hong Kong government, in particular Department of Justice, and we would like to be part of that and contribute. There's a chicken and egg issue. I studied arbitration about 20 years ago under our now former SJ, Teresa. She's my teacher. I learned arbitration from her. But over the years, I realized as a young up-and-coming lawyer, still young, at heart at least, I felt often when you want to be appointed as an arbitrator, there's what I call chicken and egg. People say, yeah, eventually it's you. But to be appointed, people ask, have you done enough cases? there's never a time, I mean, unless you're lucky to be working in a firm or at the DOJ where there are, expert arbitrators who are dispute resolvers who are there leading you. Otherwise, as much as you appreciate arbitration is the way to go, as much as you appreciate ODR is the way to go, you can't get your first case. We're here to change that. Although we only started, open our door for operation on May 25th, we've already had disputes resolved at our place. And in each of those cases, we've requested the parties, and they've all been very helpful to agree to allow young, or should I say less experienced, up and coming dispute resolvers to participate as our tribunal assistants. So that's been a quite useful thing to do. We look forward to working with different law schools and to collaborate and not procrastinate. Together we serve, and that's all I have. Largely, this is a summary, but I will need to go through. I know you've been very participative, active listener. Thank you so much. Thank you. Here to serve. Thank you.
Thank you, Nick. We still have around 10 minutes for our panel discussions. We have some questions from the floor, and maybe I will address questions to our different panelists. The first question is to Nicholas. We have heard from your presentations about the different ways of encouraging participation in the use of ODR, and also the experience in Colombia. And some participants would want to know what is the key challenges in enhancing the participation of ODR in your country or in Latin America, because that may also be equally applicable in this part of the regions. Nicholas?
Oh, yeah, that's an excellent question. Thank you. I believe the biggest challenge is the resistance to change. So I can sense that many people believe that this is the best alternative, and this is where we're going, as a humanity, but also as a society. Disputes are going to be resolved online. I think people know that. But there's a natural, I will say, bias against change. And people, even though they know that it's coming, they would say, but if I can keep having the ways I resolve disputes the way they are, I won't have the need to have recourse to these new technologies, or to incur in the initial expenses that they mean. So at the end of the day, you have to deal more with the cultural and with the mindset of people. And so at least what I've noticed, and more so after the pandemic, is that people realize that this is where we're going to. So this is the ODR is the ultimate solution for dispute resolution needs. But they just need to make the change to really embrace it, to adopt it, and not to have not to be afraid of it. So that takes time. So it's more of predicating about it. No, it's the bringing the good news of ODR to people, and being in this kind of fora where you can present the benefits. I think it really helps.
Thank you. Like, I think you have pointed out a very important aspect, the resistance to change. I think that is everywhere, not just in Latin America, in Hong Kong, and in this part of the region, maybe also in Japan and other places. Usually, what's your experience? What's the biggest difficulties in overcoming these kind of challenges in Japan?
Yes, thank you very much. And I was very impressed by the Nicholas, the intervention, and because at least in Japan, we have very too much established, firmly established, the judicial system, legal community, and which have, the traditional concept of the proceedings or dispute resolution or legal frameworks. So I sometimes, think, such a country have, kind of the difficulty to introduce a new type of the dispute resolution. But on the other hand, I was very impressed by Colombia because in the previous workshop in May in Tokyo, and I was very impressed by the presentation, the explanation of the new type of the bankruptcy process which drastically try to introduce the ODR systems and the secure transaction as well. So I think the emerging market countries have a very good chance to introduce such a drastic change of the dispute resolution system because they have not yet too much firmly established the judicial or legal systems for the dispute resolution with the traditional concept. And I came back from Africa, and but African people are really, have a great interest on these issues, and perhaps this kind of the ODR or such a new technology could change the present the landscape of the each country's status for the dispute resolutions, and at least in Japan we have so many difficulties because vested right people or vested right, the systems existed, and sometimes it is kind of the barrier of obstacle for the introducing new ones. So that is my comment.
Thank you, Yoshi. I think that you're correct that for in emerging markets, maybe they're more flexible, more open to new ideas and new means of dispute resolutions. Do you agree, Nick, for the ELCO members?
Fully agree. It's a no-brainer to use ODR when you can. There's no better way to resolve everything in the palm of your hand with a mobile phone. You could start a case, with ELCO or with EBRAM or with, other centers that are ODR enabled to allow you to not have to leave your workplace, your family, and you can deal with it at a time which is more reasonable than the time we are imposing on Nicholas today. We heard earlier, I learned earlier today that 38% of China's GDP is contributed by e-commerce, and the average purchase in the US is $58. So if you look at all these numbers, well, firstly, I say we probably run with similar numbers in, even in emerging markets in some ways, in the sense of, it's just more accessible and cheaper to buy things online because of COVID-19. People get used to that, and if you are able to make use of a platform like ELCO, with already 47 member states. But if you're not part of those 47 member states, don't feel left out. We're not leaving you out. It's just that, we're set up that way. Thank you.
Thank you,
Fully
Nick.
agree.
I have the second question for Yoshi. As you know, not all, although some ASEAN members are also part of the APEC, but not all ASEAN members are APEC members. So if ASEAN businesses are doing trade with businesses in APEC economies, but those ASEAN members are not APEC members, could they utilize the APEC framework, the ODR framework? Yeah.
Yes, thank you very much. And for example, at present, for example, listed ODR provider just limited for the ODR providers which is operating in the APEC member economies only. But at the same time, we are providing the model procedure rules on ODR, and which is only just the kind of the private document, and the party can agree upon to use the private document, and it will be incorporated into the parties' dispute resolution agreement. And this is, honestly speaking, substantially free to use for everyone or every organization. It means that, for example, one ODR provider in emerging market country, and which is out of APEC, but they can freely use this document. In other words, it is useful for smooth introduction of the ODR, the framework, even if the the ODR provider is located in the emerging market country and out of APEC. So I think this is a very useful document. And in addition, so we are now starting the ISO project, and ISO is much more open for everyone, and so anyone can use such a new standards, and that new standard could be based on the the APEC model procedure rules, but which origin is established in the United Nations work. And FAIR, and I and Nicholas and some of my colleagues and actively work, more than 5 years. And I think, such a fruitful product could be, very useful and anyone use, for the smooth introductions. Thank you.
Thank you, Yoshi. So I understand that while the ODR providers under the APEC framework are limited to member economies, but any business anywhere can utilize their services. They can make reference to their model dispute resolution course and the model rules. Thank you. So we have one last question for Nick. It's very pragmatic questions. We know that ELCO Center is promoting the use of ODR, and also I think ASEAN market is also one of the focus. So what kind of services you can particularly provide for the ASEAN businesses? Do you give them any discount, for example?
I thought it's free. No, well, training, sharing, collaboration, and since Dr. Ding has suggested discount, we have to look into it. If we got a ASEAN card, do we get special COVID-19 clearance anywhere we go? Across the customs. But anyway, we are here to provide full support in all seriousness, and I hope friends from all over ASEAN could make use of this very useful country-neutral platform to for the betterment of your people, your business. Thank you.
Thank you, Rick. I think that we are running a bit late, so that concludes our panel discussions. So could you join me to give a big round of applause to our panelists?
Thank you, Dr. Ding, Mr. Losada Pimiento, Professor Hayakawa, and Mr. Chen. So please stay for a group picture. So please smile to the camera. One more. Okay, thank you very much. Please take a seat. Thank you very much for the very insightful and detailed sharing, and asking for a discount at the very end. To conclude today's workshop, we are very honored to have invited Ms. Wong Maggie, JP, the Director General of Trade and Industry of the Government of the Hong Kong Special Administrative Region of the People's Republic of China, to deliver the closing remark. Ms. Wong, please.
Dr. James Deng, friends from ASEAN Member States and ASEAN Secretariat, distinguished guests, ladies and gentlemen, good afternoon. It is my great pleasure to join you all today at this workshop on ODR in facilitating cross-border trade and investment for ASEAN and Hong Kong businesses. Supported by the Economic and Technical Cooperation Work Program under the ASEAN-Hong Kong-China Free Trade Agreement, I'd like to thank the Department of Justice of the Hong Kong SAR government for organizing this hybrid workshop. Today is the second phase of this ECOTech project. Building on the very positive groundwork and feedback of the first phase, I'm sure today's workshop will contribute tremendously to mutual cooperation with ASEAN and benefit our participants, in particular the micro, small, and medium enterprises in the region. Through today's detailed presentations and lively discussions on the four main themes, I'm sure we have all learned more about ODR and, in particular, the value of its wider application to the business sectors. It is encouraging to note that trends and efforts devoted to promoting ODR and its application in cross-border trade and the promulgation of the ASEAN guidelines on ODR in April 2022 opens a timely window for greater collaboration between Hong Kong and ASEAN on this front. Echoing the theme of e-commerce and cross-border trade, I'd like to highlight the increasing role of e-commerce in cross-border trade. Some 10 years ago, e-commerce took up only 2% of retail sales in Asia as a whole. As of 2021, e-commerce accounted for 23% and 19% of retail sales in Asia and ASEAN respectively. And the figures are further projected to grow to 29% and 28% respectively by end 2026. The unprecedented challenges brought about by the COVID-19 pandemic have in turn provided some tailwinds to the booming e-commerce market. With the growth in e-commerce, it is all the more important to have reliable and accessible platform for resolving possible contractual disputes that will ease the minds of businesses, in particular the MSMEs, when they tap cross-border business opportunities. And thanks to the introduction of the electronic business-related arbitration and mediation platform, that is the EBRAM, businesses are now able to benefit from this efficient, cost-effective, and secure means for online deal-making and resolving disputes among parties in any part of the world based on state-of-the-art technologies such as blockchain, smart contract, and artificial intelligence. An important element of today's workshop is encouraging greater participation in ODR and capacity building. According to a study by the Asia Pacific Economic Cooperation Business Advisory Council, more than 90% of MSMEs reported that dispute resolution was one of the greatest challenges they face when trading across borders. ODR has thus become a handy solution to MSMEs as it helps resolve low-value disputes across borders and support participation of MSMEs in international trade by providing speedy and cost-effective dispute resolution through the use of technology. And capacity building will thus become crucial to promoting the wider application and utilization of ODR among MSMEs. Capacity building of MSME is indeed a subject close to my heart, as the Trade and Industry Department in Hong Kong plays a key role in supporting the over 340,000 MSMEs in Hong Kong. They constitute more than 98% of our business establishments and employ more than 45% of our workforce in the private sector. Their vitality and business performance are of crucial importance to the development of our economy. We provide a comprehensive range of free business information through the Support and Consultation Center for SMEs. We administer funding schemes to support their brand building, upgrading, and export marketing. So I, together with my team in the Trade and Industry Department, will spare no efforts in promoting ODR to MSMEs, which will boost their confidence to venture further afield to economies with huge market potential like ASEAN. Another key role of my department is to actively participate in international trade organizations and promote trade and investment liberalization. To this end, we have been actively coordinating Hong Kong-China's participation in regional fora, such as APEC, and in forging free trade agreements. Against such background, I'm pleased to note the continued development of an APEC-wide collaborative ODR framework for MSMEs in business-to-business transactions under Dr. James Deng's leadership in the APEC's Economic Committee. At the same time, Hong Kong has been actively seeking to expand its free trade agreement network in order to secure favorable conditions for Hong Kong's goods and services to enter outside markets. So far, we have signed 8 FTAs with 20 economies. FTA indeed provides an excellent platform for us to take forward projects in capacity building and technical assistance for our trading partners. The ECOTech work program is indeed one of the unique features of the ASEAN Hong Kong-China Free Trade Agreement, which showcases our joint commitment to enhancing capacity building and helping all parties to reap the benefits from the agreements. and Hong Kong China is committed to contributing 25 million Hong Kong dollars in 5 years to support the Ecotech work program. And I'm very pleased to say that a total of 21 Ecotech projects have been approved, covering a wide range of subjects, including trade facilitation, SME cooperation, e-commerce, etc. The fact that the work program is warmly received by the stakeholders reinforces our long-standing and close cooperation with ASEAN. Today's workshop is the very first project with physical participation from our ASEAN friends since the implementation of the ASEAN-Hong Kong-China FTA Ecotech Work Program in early 2020. Your presence today means a lot to us. The participation of many MSMEs representatives who are unable to attend physically is also greatly appreciated. I'm sure all of us will benefit from today's very fruitful exchanges. Ladies and gentlemen, my heartfelt thanks once again to the Department of Justice for organizing this Ecotech project. I would also like to thank all of the speakers for their generous sharing and support today. I have every confidence that the workshop will contribute to a better understanding and wider use of ODR in the region. Last but not least, to participants who flew all the way from wherever you are, thank you so much for taking your time out of your busy schedules to join us here in Hong Kong today. Please do come back with your family and friends and see for yourselves the opportunities that this vibrant city offers. And I wish you all the very best of business and health in the coming year. Thank you.
Thank you, Ms. Wong. Thank you for your support, and please be seated. Ladies and gentlemen, the second phase workshop on ASEAN online dispute resolution has come to an end. On behalf of the Department of Justice, we would like to thank all of you, our wonderful speakers and moderators, for your insightful exchanges. And thank you for attending the workshop and for making this event a very huge success. We'd also like to express our gratitude to our supporting organizations, the Secretariat of Association of Southeast Asia Nations, the Trade and Industry Department of the Hong Kong Special Administrative Region for their support for this workshop today, and the supporting organizers of the Hong Kong Legal Week 2022, namely the Asian Academy of International Law, the Hong Kong Bar Association, the Law Asia, the Law Society of Hong Kong, and Invest Hong Kong. Before you leave, please remember to return your headsets and complete the evaluation form by scanning the QR code at the back. That's next to the entrance. For online participants, please fill out the online evaluation form. Thank you very much, and we wish you a very good day. Thank you so much.